Uh, yes. Good evening, everyone. Today, after a long gap, again we'll actually start with another subject, and that would be Code of Civil Procedure 1908. Today, I'll just briefly introduce you to CPC, and there will be another class tomorrow in which we shall take it forward and then see how it goes and try to finish it as soon as possible. Uh, so let's just start with the presentation. Yes. So our topic today is Introduction to CPC. Uh, Before going into the fact that CPC deals with the laws that we need to know in order to make sure that the proceeding before a civil court is carried out well and fair trial is given to the parties that come before it. We have to know that law is effectively categorized into two types. One is a substantive law, and another is procedural law. And further classification of substantive law would be that the laws which prescribe the rights, and there are certain substantive laws which prescribe the remedies. I'll give you an example. The right prescribing laws would be, for example, the Contract Act, whereas the uh, remedy prescribing substantive law either can be Contract Act itself, or if the party is claiming a specific performance, then it would be specific performance, specific relief act, which will be the remedy prescribing act. But what is the need of procedural law? The procedural law actually lays down the mechanism. So we all know this doctrine of ubi jus, ubi remedium. So where there is a right, there is a remedy. We know that there would be a right prescribing law and there would be a remedy prescribing law. But procedural law, though uh, does not come directly under the maxim ubi jus, ubi remedium, it actually makes sure that the mechanism in order to reach that remedy, in order to make sure that that right is given to that party whose right has been infringed, that is given properly, and hence procedural law come into picture. And CPC, CRPC, evidence, all these laws are procedural laws, and CPC prescribes the procedure to be adopted by a civil court while dealing with a civil case. And there are sections and orders, and there might be a doubt uh, that why is it that there are orders and there are sections, because of the fact that there is extensive principles which were to be laid down and which couldn't be laid down under the sections, and that's the reason uh, the legislature made sure that by virtue of orders the detailed procedures were laid down. I'll briefly tell you the history of CPC. The first CPC, I mean, the Code of Civil Procedure was actually formulated by uh, uh, John Remley in 1859, but the same was amended time and again, once in 1877. But the CPC as we know it, it is actually made in 1908, and it was made by a committee headed by Sir Earl Richards. Probably all these are not required for your examination purpose, but then you need to know where your law came from. This is how it came from, and Sir Earle Richards is actually the father of CPC, uh, if we may call it. Um, uh, and why do I say that you need to know the history of CPC? Actually, I did not know about this particular fact that uh, why Sir Early Richards, when he actually formulated CPC, he actually came to India and he read the history and the ancient texts and tried to know the tradition and culture of this country, and then went ahead with the draft of CPC. Now, the question may arise that how is it that the culture and the tradition will affect a particular law? Uh, to give you an example, which I read today itself, that Section 112 of Evidence Act was actually drafted by Sir James Stevens, uh, which is actually based on Mahabharata, because when he realized that paternity has been actually a sensitive topic in Hindu society, and there is no question or there is no scope to challenge the paternity concept. And hence, the section 112, which prescribes that during marriage, if the child is born, or during substances of marriage, or during or within 270 days of the marriage, resolution of marriage, if the child is born, then it will be presumed that the child is a uh, legitimate child, and that is the person who has actually uh, uh, that is the person who has actually given birth to that child, and who will be the father of the child. So in that case, so you need to understand the history in order to make sure that the law will be effective. So in short, I told you what is the history of CPC, and how Sir Earle Richards actually made sure that the CPC as we know it, though it was formulated in 1908, still acts good, and no such major amendment has been uh, done to that. So now let's know the ingredients of a civil suit, or the elements of a civil suit. I am telling you all this again because this is not directly mentioned in the act itself, but you need to know all this in order to make sure that you understand the civil procedure as a whole. So what are the ingredients or elements of the civil suit? First is that there must be a cause of action. Without a cause of action, a civil suit cannot sustain. And what is a cause of action? That cause of action is nothing but the reason to file a suit. So there must be a right, and that right has been violated by someone, and then you have a reason, because someone violated your right, you have a reason to file a suit, and that reason is nothing but the cause of action. Then the subject matter, it is nothing but the subject in respect of which the right is clear and the suit is filed. That is the subject matter. The third element would be relief. That is, if the remedy, we all know that there is a right. If there is a right, there will be a remedy, and the remedy, if we claim from court, then that would be relief. So of course, if your right is breached someday, you suppose somebody came into your house and evicted you from your house, you have a remedy to actually take back your own house by using force. That would, though, be a remedy, it would not be a relief. A relief would be if you claim that remedy from the. And the fourth important element of a civil suit would be parties. So, generally known as plaintiff and defendant, and it can be petitioner and opposite party, it can be applicant, respondent. So, as the case may be, the parties can differ. We'll all discuss all of this, the necessary party, what is a necessary party, what is a proper party. Anyway, I'll tell you what is a necessary party and what is a proper party here as well. But anyway, we'll discuss it while we will be studying orders in the subsequent classes. Necessary party is a party without whom no effective adjudication is possible. But proper party is a party without whom an effective adjudication can be done. But then the finality to that question, which is before the court, that cannot be done. So this is the difference between a necessary party and proper party. We'll study them at length later as well. Non-joinder and misjoinder. It is very clear it has been made clear by the CPC that non-gender and misgender of party would not adversely affect unless if there is a non-gender of a necessary party. And pro forma defendant, that is another concept that we'll also study later. But I'll tell you in short now that a person who was to be added as a plaintiff, but he was not interested in pursuing the suit. In that case, you may add him as a pro forma defendant, and later he can be transposed or whatever can be done. But he needs to be added because without him, an effective remedy cannot be reached. Now coming to the fifth element, that is title. That is, title is nothing but the legal capacity in which the suit is being contested, or the suit has been filed, or the person or the defendant is actually contesting the suit. That legal capacity is the title. So if in a matrimonial suit, the legal capacity of of the wife, he's contesting as a wife. So in that contest, her legal capacity would be the wife. I mean, the status of the wife. Now, what is a matter in issue? This is the sixth element. That is that the facts or the mechanism which are to be proved to win a relief from the court. For example, if I am filing for a partition, then in that case, I have to prove that I am the son of my father. So, how I am succeeding him, that I have to prove. So, this is a matter in issue. If I am contesting as a wife, then I have to prove how I am married to X. In that case, the matter in issue would be the fact that I have to prove that I am the wife of X. So in this case, all these six elements that we discussed, these are very important elements without which the civil suit cannot be sustained. Now, section one, though it is not important, it we should all know that it extends to whole of India. Sometimes it is asked in preliminary that whether to which state or which areas the CPC does not apply. So you need to know it doesn't apply to the state of Nagaland or tribal areas that are specified. But yes, the government can very well modify any of the such tribal areas or any part of the Nagaland and bring it under the purview of this code as well. Coming to the all important definitions, which are really important if you need to understand CPC later. First would be decree. What is a decree? Let me tell you, I have heard that many people pronounce it as degree. It is not degree, it is decree. Uh, I have seen it. I've heard it. That's the reason I'm telling you. It's decree. Decree is it is nothing but a formal expression of an adjudication made by a judge after actually hearing both the parties on merit, and then giving a formal expression of that decision. That will be a decree. And we have to know that after the judgment only, the operative portion of that judgment, that whatever is decided, whatever is the conclusively, I mean, either it is determining the rights of the parties, though those that conclusive part, that very objective part, if that is formally expressed, then that would be a decree. It can be either preliminary and final, or it can also be partly preliminary and partly final. When will it be a preliminary decree? If a decree has been made, but then there are other issues which are to be taken up before the final disposal of the suit, then it will be a preliminary decree. For example, uh, if there is uh, a suit for possession and claiming possession and claiming mean profits, then in that case, if one issue is decided but the other issue is left out, that would be a preliminary decree, because you are just deciding on the possession part and the court has not decided yet on the mean profit part. Then in that case, that would be a preliminary decree, because there are other issues which are to be taken up before the final disposal of the suit. In Sankar versus Chandrakant case, this Honorable Supreme Court has rightly held, and it has actually they have actually uh, made it clear that deciding any rights and liabilities without actually deciding the result, that would be a preliminary decree. So in simple language, if we have to know what is a preliminary decree, we should know that the if the court is deciding the rights and liabilities without actually deciding the result, then in that case that would be a preliminary uh, decree. And when will it be a final decree? When it completely disposes of the suit. So basically, if in the same question, if the uh, uh, possession and mean profits are both decided together, then in that case it will be a final decree. So, for example, if in a partition, the partition was actually decided and the decree is drawn, and then in that case it finally disposes of the suit. So, in that case, it will be a final. And it can be it can be also partly preliminary and partly final if certain issues are finally disposed of, but certain issues are left out. And in that case, it can be partly preliminary and partly final. Now there is this provision of deemed decree. So it is nothing but a fiction of law. That law is suggesting that though specifically the points that are, I mean, the this rejection of plaint or the determination of a question under restitution under section 144 CPC, these two, those specifically do not fulfill the criterias of a definition of a decree. As we studied, the definition of decree is that it should be a formal expression of an adjudication arrived by a court or a judge after hearing both the parties on merit. Then in that case, it has to be a decree. But these two uh, thing, that is rejection of plaint or a determination of a question under restitution under section 144, though do not fulfill the criteria of a decree, will be treated as decrees because of the fact that law says it so. So then coming to the exceptions, that which are not decrees, that adjudication of an applicable order, that will not be a decree. So if there is an appeal from an order from which an appeal lies, and the adjudication of that particular uh, uh, order, then in that case that will not be a decree. And second thing which will not be a decree is order for dismissal of default. That will also be not a decree. So if for default, for default as in, for example, I mean, to understand it, if the party does not come to the court and the court dismisses the suit on the basis of the fact that the party defaulted, then in that case that will not be a decree. Now, what's a consent decree? Time and again it happens that both party come and they later decide that they do not actually want to pursue the case in the court any further, and they have decided within them that they have decided within themselves that this is the decree that they want to draw. I mean, this is the conclusion that they want to arrive at. Then in that case, they can very well file a compromise petition or a consent decree. I mean, they can file a petition to that effect, and a consent decree can be drawn on the basis of that. What is an ex parte decree? If one party is set ex parte, that means one party, the court called again, but the party did not show up even after exhausting all the modes. Then he was declared ex parte, and in that case, if the party who is pressing the issue, if he suggests so, then in that case, an ex parte decree can be drawn. We also have to know that a decree can be also amended later, either on application of the party for a clerical error under section 152 and suo motu by court under section 153 of CPC. And another important thing you have to remember about decree is that if there is no appeal filed by a party against a preliminary decree, then in that case, while challenging the final decree, the correctness of the preliminary decree cannot be challenged. So basically, it is again, we'll study res judicata later, but it is like a res judicata, because you could have challenged it then and you did not challenge it now, to make sure that a party is not given scopes unnecessarily. This provision has been made. So if the preliminary decree is there and no appeal has been made by a party who is aggrieved by it, then he cannot challenge the same while challenging the final decree. Now, what is the difference between a judgment and a decree? This can also come as a short question. So you have to know that judgment is defined in section 2.9, decree is defined in section 2.2. Judgment is what? It is a statement given of the grounds of order or decree. So why did the particular judge or court reach at the conclusion of that order or that decree? The whatever the statements given, whatever the grounds given, those statements given of the grounds, those will be the judgment. But as we all know, what is a decree? It is a formal expression of an adjudication after actually hearing both the parties on merits, and then whatever operative part, or how what the rights being determined of the parties, that operative part is the decree. Uh, in a decree, the formal expression is absolutely necessary, but in a judgment, formal expression is not necessary. In a judgment, the reliefs are decided, that whatever reliefs are to be given, and in the decree, the rights of the parties are decided. And you also have to know that a judgment always precedes a decree, and decree is always followed by a judgment. Now coming to decree holder, section 2.3, that is, from the name itself, you can know that a decree, whoever is holding a decree in his favor, that means a person in favor of whom a decree is passed, that will be a decree holder. And also a person in favor of whom an order capable of being executed that has been made, he shall also be called a decree. Now coming to foreign court, that is a court outside India, but and not established by the central government. Outside India would have sufficed, but why was the provision? Why was the particular term that not established by central government was used? Because we can say that if a court is outside India, then of course it will be a foreign court. No, it is not so, because this CPC came into force in 1908, and 1908 we were ruled by the Brits, and they had established courts beyond that India as well, and which was not uh, inside India, but they were not considered foreign courts. For example, Privy Council. But now, of course, after the Brits left, yes, Privy Council is not a foreign court. I mean, it's a foreign court now, and it is not a court within India right now. Foreign judgment is nothing but a judgment delivered by a foreign. And legal representative, defined in section 211, that is a person who in law represents the estate of a deceased person. These short things you have to remember. Sometimes it comes in preliminary, sometimes it is also asked as 2 marks question in the mains as well. So we have to remember all of this is important. I've missed out some of the definitions which are not important at all. There is this definition of India, which is a very peculiar definition. It says that India means India and does not include Jammu and Kashmir. So all these definitions are there. Now coming to mean profits, that is section 212, that is profits which are actually received. So mean profit is nothing but a profit received in the meantime. So basically, a person who should not be in possession of to give an example, that a person actually came to my house and I came to my field, I mean, a land where I had cultivated crops, and he uh, drove me away from my um field and actually was in possession of that property for some time, I mean, field for some time. And in between, he has actually cut down the crops and he has sold them off. So he has received a certain profit, and he was in wrongful possession. And in that case, whatever profits he has received within that time, those will be called mean profits. Though it is written MESNE, it will be mean profits. Mean profits. Uh, uh, those are the profits that have been received, or for the fact that the law actually goes a step ahead and says that whether actually received or not, it doesn't matter. It says that actually received or with ordinary diligence might have received. For example, if the person later says that no, no, I have not cut down the crops, actually somebody else took it away, or a cow came, I mean, some cows came and they ate the crops, he cannot take such pleas, because as per ordinary diligence, we are of the opinion that yes, he must have received the profits, and probably he's making a wrong assumption. So in that case, these will be mean profits. But yes, if he has made any improvements, though even though he was in wrongful possession, for example, in the same example, if he took over the field and then later he dug a well there, and from that well he probably he got some profit out of that, and in that case, those profits made due to improvements, they will not be considered as mean profits. Movable property, the definition of movable property has been given again, and that is uh, not an exhaustive definition. It just says that it includes growing crops. It includes growing crops. That much it says. But the question comes that whether standing timber, because it says that growing crops, so means that if a tree is standing, whether that will be a movable property. Uh, uh, this question again, my habit of asking questions to you. This question, please answer yourself at the end of the session. Remember someone and ask whether standing timber will be considered a movable property, and if not, then why, and whether it shall in fact be considered as a movable. Order is nothing but an formal expression of any decision of a civil court, not amounting to decree. So when a judgment is done, there can be two things that can arise. Either it can be a decree or can be an order. If the formal expression which is satisfying the criteria of a decree, then that will be a decree. If it is not a decree, then it will be an order. And who is a public officer? That has been given in section 217 of the CPC. It says that a judge is a public officer, a all India service member, that person will be a public officer. A navy, air, military, uh, if he's a gazetted officer or a commissioned officer of all these, they will be public officers. Officers of court of justice, officers in office vested with power to confine someone, all of these persons will be public officers. Other things are also given. You please just go through that once. Now, the section 3 actually says the subordination of courts. That means the hierarchy of the courts. So we have to know for a fact that the high court is at the pyramidal structure's top. So first high court, then subordinate to that comes the district court or the district judge court, and then comes the civil court. So civil court, but there is further distinction, and that will be a civil judge senior division, and below that there will be a civil judge junior division, and then comes the small causes court. This is the hierarchy of the civil courts that has been given in section 3. And then section 4 is nothing but it is saying that it will not affect or limit any special or local law. So for example, if there is any special law which is uh, telling or which is narrating about the fact that it should be the proceeding should be conducted in that manner, then in that case it will be conducted like that. So section 4 is actually a savings provision which says that it will not affect or limit any special or local laws. Now coming to section 5, that is it is applicable to revenue courts only in absence of a special law. So not ordinarily the civil procedure code will not be applicable to revenue courts, but only in absence of a special law they will be applicable to revenue courts. But you also have to know that what is a revenue court? A revenue court means a court having jurisdiction under any local law to entertain suits or other proceedings relating to the rent, revenue, or profits of the land used for agricultural purposes, but it shall not include a civil court having original jurisdiction to try all this. So this is a definition given. Now coming to section 6, that court can ordinarily done, I mean, or not ordinarily, court can in no way break the pecuniary jurisdiction that has been fixed. And what are the pecuniary jurisdiction? That is the pecuniary jurisdiction means the monetary jurisdiction. So ordinarily we have to know that there are two classes of civil courts. One is civil judge junior division, another is civil judge senior division. So these are two classification on the basis of pecuniary jurisdiction. If there is a civil judge junior division, which is now not called civil judge junior division anymore, previously it was called munsif, but now also that nomenclature has been removed. Is just called a civil judge, and the pecuniary jurisdiction of that would be rupees 50,000. Though I really believe that it's time to amend it, because 50,000 is nothing. 50,000. Imagine a piece of land you can purchase with rupees 50,000 in Katak, Bhubaneswar. Probably that would be just a hand, or I don't know how far is that practicable, that you still go ahead with this pecuniary jurisdiction of 50,000. But yes, it is still so, and the pecuniary jurisdiction of a civil judge is 50,000, whereas the pecuniary jurisdiction of a civil judge senior division and upwards. So basically, if that's not a civil judge, uh, I mean, he has reached the stage of senior civil judge or upwards. That means the district judge, high court, and other courts. Those for those courts, they will be having unlimited pecuniary jurisdiction. That means if a case of 2 crores is filed, 100 crores is filed, doesn't matter. They can still entertain. So yes, the odd rule is that never a court can break the pecuniary. So basically, the pecuniary jurisdiction is specifically meant for civil judge junior division, or a civil judge, as the case may be, because he cannot break the rule of 50,000. And if the case, if the suit is exceeding that value, then the civil judge will not intervene. But then again, as we all know, the plaintiff is the master of the suit, and time and again we have seen that plaintiff always actually tries to undermine the value of the suit property in order to make sure that the suit comes under a lesser pecuniary value, because of the fact that he has to pay court fees again, unless he is exempted by virtue of the fact that belonging to a specific caste, or for the fact that she's a woman, or the fact that she has an income as prescribed by the government. In that case, there is an exemption to file court fees. But if not, then obviously, if you show your property as 2 crore, then you'll have to file a court fee uh, of that amount as well. I mean, proportionate to that amount as well. So that's why plaintiff, being the master of the suit, and plaintiff can very well determine. Of course, the court can again intervene and say that no, this is not the proper valuation, because if someone comes and says that I have 1 acre of property at Patia, or Jade Vihar, or Nayapalli for that matter, and he says that the suit value would be 50,000 or less. The court should not ordinarily accept that, but the plaintiff is is well in his capacity to make such pleas and try to bring down the pecuniary jurisdiction, uh, to make sure that the court fee is lessened. Now coming to section 7 and 8, so which is nothing but again a saving clause, in which says that the CPC will not be applicable to provincial and presidential small causes court. So this was probably the introduction to CPC. I know it was a small lecture. Tomorrow we'll actually take it from section 9, and also discuss section 10 and 11 if the time permits, and uh, will though that will be an important class. I'm not discussing a lot of the topics today, because probably this is the first class, and some people might not be aware of it. So this was just an introduction, and tomorrow, being a holiday on the eve of Janmashtami, I hope all of you will be free, and I hope we can make that session a productive one. And now, if there is any doubt, I'm sure there would be no doubt because the class was, in fact, very short and it was. My voice is not audible. Is it? Is it true that it was not audible throughout, or was it? Please, someone confirm because
Audible, sir. Audible.
okay, because I got scared because it was written at 5:07 and it's almost the end of the class. If it was not uh, audible, then that would have been terrible. Anyway, if there is any doubt, then please ask, or otherwise we'll just end the session here. Tomorrow it will be a long session, and please be free at 5 so that because that is in fact the most important uh, session I believe because section 9 is very important. Section 10 and 11 are again very important both from the point of view of examination and also to understand CPC in a better way. You have to know all these preceding sections that we'll discuss tomorrow, section 9, section 10, and section 11. So we'll take up the class tomorrow. Is there any other? Uh, there is any doubt, or we'll just end it here? I have some work anyway, so I kept it very short today.
Good evening, sir.
Uh,
Sir, you had
yes,
asked a question about standing timber, right? So
yes,
whether it is a
yes,
movable property or not. So
yes.
to clear that point, TPA itself says that immovable property will does not include standing timbers. It doesn't
Mm,
include standing timber, growing crops, and all. So from that point of view, it will definitely be included in movable property. Furthermore, if some trees which both produces timber are being used for the purpose of timber and as well as fruit, Supreme Court has also clarified to that effect whether that will be treated as movable property or removable property. It will be seen that what is the intention of parties. If it is seen that the tree is being used for further vegetative growth, then it will be like immovable property. But if it is being used for uh, say for cutting woods and for building houses on a particular period, then that will be treated as movable property.
yes, true.
That's my answer to that.
That's a good answer. Does anyone want to vary from that, or they're agreeing to this view? I just saw another question asked by someone. Subhashis probably asked that is there any pecuniary jurisdiction of appeals in civil cases? Uh, uh, can anyone answer this question? Can anyone answer this question? Because I believe that's a very simple question, so that's the reason I'm asking if anyone can answer it.
Appeal is a continuation for proceeding.
So Asif was
It
answering.
is
Asif was
different.
answering.
Sir, good evening,
So
sir.
pecuniary jurisdiction should apply to that, right? What are you saying?
Yes, it's a continuation proceeding. So whatever the value of the suit, it is to be determined on the basis of jurisdiction of the court.
Right, but then the problem here is who before whom will you appeal? I mean, you can't appeal before a civil judge, junior division, right? I mean, against which order will you appeal? Because already you are at the bottom of that pyramid, and you are already determining suits which are below 50,000, and above you, all the appellate courts are there. So I don't think it will, though it should ordinarily apply, but then there is no scope of applying it for the fact that there would be no forum, which will be in fact be prejudiced by the pecuniary jurisdiction while considering an
Hello, good evening, sir.
appeal.
Hello,
With it.
sir. Actually, my question is that Suppose a case is filed in a sub judge court, suppose amounting to rupees 10 crore or more. Uh, so if anyone wants to appeal, then in which court? Means district court, he can appeal in district court or in directly in high court. So my question is
No,
that.
no, we'll have to always approach the district court first and then go and if the district court does not entertain, then there would be a provision. We'll obviously study the first appeal, second appeal, when first appeal is preferred, on what basis second appeal will be entertained. We'll study all of that. So bear with me, and if you attend all of the classes, I'm sure we'll take up one issue after another and make sure that all your doubts will be cleared. For now, just know that the hierarchy that I mentioned: civil court, civil judge junior division, civil judge senior division. So civil judge junior division's order can be appealed before civil judge senior division. Civil judge senior division's order can be appealed before high court, district court, and then it can be challenged before high court. Yes, of course, second appeal thing when we'll study while deciding the point of only when you are appealing only because a substantial question of law is involved, we'll study all of that. Because if I start discussing it now, it will be again another discussion altogether. So let's keep it for later. Tomorrow we'll start with section 9, section 10, and section 11 of CPC. 5 o'clock will be the time, and we'll make sure that it will be a good one. Thank you, guys. Have a great
Thank
day.
you.
Stay safe. Bye.